Welcome to this episode of My Ramblings. This episode, we talk about contracting for engineering services. One of the things that I spent a lot of time doing, and it took up a lot of my personal time, was you don't learn the NEC at the university, but Jesus, these guys were expecting us to know it. I'm a civil servant. They're supposed to follow the civil service rules, and they're supposed to give you developmental projects up, and they're not supposed to, make you have to go spend 2 hours a day off the clock learning, and tens of hours a week in the library trying to, learn the NEC and what's behind it and all of that. But well, the other things I was doing is I was reading a lot of trade magazines or profession oriented, electrical engineering oriented magazines. They had one on specifications, and I really liked that. There's too much to consume regarding specifications, but I think this is the one that usually had an article in their section called the Legal Corner, and I would always read those. You got a good indoctrination, or I did anyway, to the legal aspects of these contracts, because they are contracts, and there's federal regulations you have to follow and stuff. And so I was always particularly interested because you want to know. You can have your opinions, you can have your guidelines. You know what the elements of a contract are. I mean, I had a guy introduce himself, and I'm talking to him, and he was saying, "Oh, yeah, we have a we sell products to the government and stuff." And you just introduce himself to the normal social thing. You shake the guy's hand. He looks back, just, we have a contract with you. Well, how do I interpret that? You know, so it's quite plausible and reasonable to assume that he was telling me, oh, by the way, um, I'm not here trying to sell you something. I'm here to let you know that we have a contract, and so that if you do need these goods and products that we provide, that we're a source for you. I didn't have any contracting authority, but God, I'm thinking, Jesus, did that guy think just because we talked for a moment and he shook my hand that he established a contract? Contract has three particular aspects that need to be met. It needs to be a meeting of the minds. Well, it doesn't mean that you meet with somebody and you talk about general things and then you shake their hand. There needs to be a specific set of services delineated. There needs to be specific compensation that's delineated. It's talking to somebody briefly and shaking their hands does not establish a legal requirement. I mean, a legal contract. But anyway, I digress. So one of the things that these guys were talking about is, there was contractors trying to get a shift and trying to push their version of a contract for engineering services on industry. And you can understand why. Usually an engineering firm has a contract with the owner. That's where the contractual responsibilities lie. And then the owner goes out and he contracts with a construction contractor. And one of the things I learned as a student, we had a lot of smart people working there. And one guy that was really intricately involved. I guess these issues were coming up on his projects. And one of the things that I learned is that if an architect engineer makes a mistake, um, you know, we the government can't go after them for that and say, hey, you forgot to include this in your drawings, and because you did, now you have to give us the money to buy that. I was really surprised. I didn't know that. I don't have anywhere thing close to a sophisticated legal background. Just we just have some constitutional issues in seventh or eighth grade, I think. But and I took a business law class, and I understood um, bailments, and it's not bail to get out of jail. It's the um, degree of care that's necessary. If you're doing something for a friend, you know, the degree of care that would be required for the agreement is different than if you had like a written agreement that you were going to do this favor, but then you were going to get compensated somehow. You know, there's a whole different standard of care. Um, that's bailments. Um, so one of these articles was about, you know, um, Contractors Association's version of contracts for engineering services. When I got out, as I was heading, getting to the point where I get tired of working for the government, and when I actually was no longer working for the government, I had been spending a lot of time on the NSPE, National Society of Professional Engineers, um, and they have versions of their contracts and stuff, and they're different. And I think the reason contractors wanted their version is they wanted a direct contractual link between the services that an engineering firm or architectural firm, for that matter, provides to an owner. Instead of having that contractual legal relationship, they wanted a contractual legal link between the engineer providing those services to the owner and the construction contractor who was implementing what the construction contractor was building. Now, you know, there may be some minor things where if an engineer leaves something out, we're not talking about stuff that's on the scope of negligence and stuff. Um, we're, you know, we're talking about stuff that maybe should have been included. It doesn't affect life or limb. I don't know where that legal branch goes. Um, and the legal basis and stuff for this, as was explained to me, is that, well, if the engineer or architect had included that in that, well, then the owner would have had to pay for it. And so by rearranging public works engineering department and stuff like that and trying to get errors and omissions by using general people and stuff like that, you know, they're making business decisions, and you know, they have to accept the ramifications of doing business that way. But they still would have had to pay for it, something that was left out. And so whether you had a good set of drawings or a bad set of drawings, you know, that would have been needed for the project, so the owner still would have had to pay for it. So the insurance company that a private engineering firm would have would not be obligated to pay that. Now, when would they be obligated to pay something? I don't know. There's a lot of negligence cases out there, I guess. You know, usually if you look at the news bulletin from California Professional Engineering Government Agency that oversees licensings and stuff, you can look through it. And usually where you see people making mistakes and are civil engineers and grading and stuff. And usually when you look at the other disciplines, it's somebody practicing without a license. And you know, that's another big, what I see as a flop in what was going on in the Public Works Center. Because, you know, if I worked as a private individual selling engineering services to somebody, I would have to be licensed to do that. But the state licensing laws for engineering don't cover how the government manages and organizes its personnel. So, you know, I guess for convenience, you know, when you come out with a degree and the government hires you, you know, your payroll classification and title is based on the discipline that you graduated with. And, you know, it's trying to, I don't know what a good comparison. I want to say grounding systems. You know, it's like you're mixing two different grounding systems when you try to take private industry knowledge with regard to that and mix it with government personnel organizations. Um, you know, it's like I was saying, well, there's a correlation between the value of a French franc and a United States dollar or a British pound. You know, there's a lot of translation that needs to be done to come up with the equivalency. But this is about the one issue I really want to undertake is that I want to make sure that I touch on is one of these articles was dealing with an attempt by some owners to shift their business risk to the architect or engineer. There's a lot of risk in starting up a business. Everything has to go right. If the market collapses, know, so there's business risk. People are rewarded for the risk they take with profit, and they're rewarded for bad judgment and bad decisions with going out of business. But so one of the key things that they were focusing on is some people were trying to shift the standard contract for engineering services where you have to provide a certain level of standard of care, and I guess that is determined by industry practice and what the courts have ruled on it. But they're trying to shift it to, you have to please me type of contract, to the satisfaction of is the words they use. And you always have to read and look at your contracts for that type of verbiage if you're going to do engineering services. In California, you're not allowed to have a contract for engineering services unless it's in writing. That's just the law in California. Because what ends up happening then is somebody can say to you, I'm not satisfied with this. I want to modify this or change this. And contractually, you might be stuck. You have to consult an attorney, but that's the general purpose. So, I understand from reading through that article too that some of the business risks and costs beyond like litigated damages and stuff like that, where some owners were trying to incorporate verbiage in their language that shifts the risk of them starting an enterprise or undertaking something over to the architect. And it's like, which, when sometimes you do separate contracts for engineering services directly to an owner. And so you really have to be careful. Some of us, when you can't afford an attorney, you got to make sure that you're very careful about the contracts that you sign. Anytime I never actually got a client beyond, a mere $15 or $25, $30 charge, but I stick with the NSPE versions of the engineering services contracts. That's, the firms I work for, I have no control over what contracts, they sign. I just, someday I might have moved up there, but moved up into where they would have considered my input on those. But so that's, those are some things that you have to watch out for. A contract is legally binding. The government, I don't say the government. And I hate to always say this because I don't speak for the courts. I don't have the legal expertise to I try to consult an attorney when I need to, but so I'm going to use this terminology, take it with a grain of salt. From what I understand, the courts have found that entering into a bad deal is not sufficient cause for the termination of a contract. So you have to be careful about the contracts you sign. You better stick with the NSPE if you're not legal savvy, such as I am not. So that's some very important issues that that you have to keep in mind. It's like when you get in a car accident. Don't let somebody convince you that it's your fault. Just exchange information. Let the insurance company or your attorney figure out who's at fault. Same way, with somebody's trying to claim you owe them money for a contractual thing. It's you want to try to work out things and help them solve their problems, but you want to be careful about not accepting liability for something for which you weren't legally required to do it. You kick that back to the insurance company and their lawyers to resolve. A lot of people just assume that because they think that you owe them something, that you owe them something. So it might possibly be that some people think that just because they shook your hand that they have a contract. this was kind of a problem. So I was always trying to be aware and alert that, and make sure you understand this isn't a contract when I interacted with contracting people. And you know, um, you have to get signed documents from the contracting officer before you proceed on this when they would discuss stuff with me. But typically everything is done in writing. Requests for information are done in writing. They have to be because you have to document this stuff. Partly to protect yourself, partly for the contractor to protect himself, so he doesn't go run off if you have, you know, a guy that's going to come back and say, well, he said I could. But partly also so that, the contractor has, written authorization so that he doesn't inadvertently go do something that's expensive for him and then doesn't, stuck in a situation where he may or may not get compensated for it, depending on, the rules and regulations that the contracting officers operate by. But one thing for sure, as we know, is that contractor can't contract out anything unless they have verified that the funds are available. That's one of the things I learned working as a student employee. So if anything I ever had or want goes off to a contracting officer, and if there's, so but so just some of the contractual things one might want to be aware of. Thank you for tuning in.